Hello and welcome everyone. Delighted to have you here today for our roundtable that cuts to the heart of what causes all too many companies to struggle. According to Harvard Business Review, 65% of startups that fail don't go down because of cash flow or profits, but because of internal misalignment and disputes. In other words, it's all too often not the business model, it's the boardroom. And that's why today's conversation really matters.
I think a lot of the triggers relate to personalities, supporting actors contributing beyond what the founder acknowledges.
The boardroom, for better or for worse, is a cesspit of very big egos. When it comes to money, it's always can be a bit touchy.
Or what you additionally need to think about would be how are you going to settle,
is you catch it much as early as possible, and take action on it.
Meet Melanie Ho, partner at One Partnership and head of enterprise disputes. She's the go-to counsel when stakes are high and reputations are on the line. Next, we have Jeremiah Huang, principal at Everstead Law, named one of Singapore's most influential lawyers by SBR and a Legal 500 next-gen partner. Next, we have Mr. Ray, with over 15 years of banking experience and now as co-founder at VIVOS, he guides businesses through ASEAN expansion. And finally, we have Mark Tay, Associate Director at Asia Practice, with a sharp eye for strategy and a steady hand in complex cases.
I cannot imagine if my wife now and said, you know what, I really love you, but I think we should get a post-nup done.
Hello and welcome everyone. Delighted to have you here today for our roundtable that cuts to the heart of what causes all too many companies to struggle. Let's be honest, most boardroom blow-ups and disputes don't just happen overnight. First they simmer, slowly they build, and then unfortunately, often, boom. In fact, according to Harvard Business Review, 65% of startups that fail don't go down because of cash flow or profits, but because of internal misalignment and disputes. In other words, it's all too often not the business model, it's the boardroom. And that's why today's conversation really matters. And we've invited today 3 legal powerhouses who've not just seen these situations play out, they've helped prevent them, fix them, and redesign governance that works. First, Jeremiah Huang, recognized as one of Singapore's most influential lawyers under 40, Jeremiah is a go-to advisor on M&A, corporate governance, and conflict mediation. And his track record spans the capital markets, compliance, and pretty much everything in between. And second, we have Melanie Ho, head of professional and enterprise disputes at One Partnership. Melanie has led some of the region's most complex white-collar investigations, and she's also the first Singaporean appointed to be the appellate board at Dubai Healthcare City. Last but not least, Mark Tay, with a sharp focus on cross-border finance and restructuring. Mark's the one companies go to when they need governance tightened, realigned, or rebuilt, quietly and effectively. These aren't just legal voices, they're conflict de-escalators, strategic thinkers, and governance architects. So settle in, you're about to hear what happens behind those closed doors and how the smart companies stay one step ahead. So we're going to get started today with some questions around this topic. So let's begin. I was going to ask the group here, and maybe I'll put the first question to Melanie. From your experience of enterprise disputes, what are the most common triggers you've seen in boardroom conflicts, in fast-growing or founder-led companies?
Yes, as you mentioned, Ivan, I think a lot of the triggers relate to personalities. Now, personalities beyond the lead actor, which we know to be the founder, and then you have what we know to be the supporting actors. And as a company grows, you have some supporting actors perhaps contributing beyond what the founder acknowledges, whether it be in terms of bonuses, remuneration, scope of work, duties, the dissatisfaction from a perspective of the supporting actors is what I see to be the main trigger.
And Mark, what sort of experience or examples have you seen?
I think I agree with Melanie, but I think the other trigger would probably be a bit of a lack of documentation or some sort of governance structure, especially in founder-led companies which have just been incorporated or started. So I think many of them view legal costs as an extraneous cost that need not be incurred at the start. And that is, unfortunately, I feel a bit of an issue because we often have clients coming to us with already a growing dispute, which could have easily been settled by proper documentation of, expectations at the start.
Yeah. It's such a common situation, isn't it? You realize that it's so complicated to unwind if you haven't done the preparation in advance, but that people neglect this up front. And Jeremiah, what's been your experience in this case?
So I think Melanie really hit the nail on the head here as to what, moves an enterprise dispute and kicks it into high gear, right? A lot of times it's personality. The boardroom, for better or for worse, is a cesspit of very big egos, very often, more often than not. But for me, as a corporate lawyer, I try to see the best in people. I don't think anybody joins a board to just force upon others his or her views. And I think the really, or at least from what I've seen in my experience, has been this, right? Very often when enterprise disputes occur, it's not so much, a personality thing at the start. Although that really is what, as I mentioned, right? Rocket ships the whole thing into this massive problem down the line. I think very often it starts with divergent visions and strategies about the business. Like I said, no one's actually joining a board to just force upon other people their ideas. They join a board because they've got ideas about a business and how it should be run. Usually with profit making in mind. And when it comes to money, it's always it can be a bit touchy, right? And people with different views are going to clash if they think that their view is going to sound in a better outcome, either for the organization as a whole or for them individually. They are going to insist upon it. For me, when I think about enterprise disputes and I were to trace the genesis of it, very often it starts with just a disagreement on, the business, either as a whole or on a specific topic, right? And then that's where personalities come into play. It then, takes that little seed that's been planted, that little disagreement, that doubt, that insecurity, and then it just propels it into a life of its own. And then what Mark said about documentation, that goes very much into ameliorating and mitigating some of, the negative effects and adverse consequences of disputes that get blown up into into something more than everybody sort of expected.
Yeah, great points, Jeremiah. I guess everybody on the panel seems to agree that disputes will inevitably come along, and that with egos and sensitivities and personalities, these probably can't be avoided and they need to be prepared for. And I think I heard from all of the panelists as well that actually there's a lot you could do in advance to prepare yourself for how you could manage this. Melanie, back to yourself. What kind of advice would you give people to say, if you see red flags or you see warning signals, how would you prepare? What could be done?
So the starting point, let's move a step back perhaps before the warning signs and the red flags. I think a starting point would be to set up what I would call an internal structure. It could be in terms of designation. So there is a very clear delineation of duties, of scope. Like I said, that feeds the recognition part of the trigger I was mentioning, right? You attribute a scope of duties to the right person, and that person feels that they are properly recognized. That's the first. Obviously, I'm talking about a holistic vision. So I agree totally with Jeremiah that there must be a roadmap to the vision, the 5, 10, 20-year roadmap that we all see in all companies for our firms as well. And this is going to be the seed that drives the business growth, with each pilot taking one segment of the business fundamentals forward. Then the second part, which I think Mark alluded to, would be what we would call governance, what the corporate and dispute lawyers would call corporate governance. And this sets out the fundamentals of the financial governance, regulatory, risk or compliance, which is the term of the year, risk compliance, regulation, as well as, of course, HR does cause problems as well if you don't manage that. Reputational risk are very closely related to HR risk. So these, I would say, would be the three key areas of any business, whether in a founder setup with the vision of a 10-year growth, upscaling themselves into multi-jurisdictional. You need to have these three fundamentals. And red flags would be when someone doesn't want these fundamentals to be placed. So again, I agree with Jeremiah. No one comes in to a race trying to stop the race. People are joining to add fuel to speed up the growth of the company. But when you see an individual or maybe segments of the company sort of impeding what would be a roadmap that would be in the best interest of the company, I think one has to stop, take stock, and see whether that person or persons are the right fit. And is it better to cut now or to perhaps manage the situation in a consultative manner to diffuse any potential triggers, red flags?
Thank you, Melanie. Jeremiah, any practical examples or situations from your experience that you've seen this sort of situation, and what have you been able to do?
I do, and actually, it ties in very well with Melanie's point, and I'm so glad that she led her views with, by taking a step back and acknowledging that, if you're only reacting when the early warning signs, the red flags appear, you might be a little too late. You might be a little too late. And this goes to Mark's point as well, right? That really, ideally, you want to be in a situation where you've already got a very clear process and procedure in place, um, to manage and to deal with, these so-called warning signs or red flags, as you put it, or I much rather the term just issues, right? Points of disagreement early on. I have a very real example of this. So I was quite lucky to represent a. Now, I can't go into the details because this is a public deal and it's out there in the wild. So I won't go into the details for fear of my client being identified. But the gist is I represented a top shelf specialist in their field. And they did a joint venture with this other company that is a conglomerate in another jurisdiction. And because, it involved two very sophisticated, very savvy parties, managed, run by very big personalities, the negotiations in relation to the shareholders agreement were not the easiest, right? Everyone had different views, citing their past experience and saying how well it worked for them. We got to the deadlock resolution mechanism eventually, and I just couldn't agree with their lawyers as to how to deal with it. And eventually, I guess all the directors got sick of us as well, and they eventually gave the instruction to both councils: drop this point, replace the entire deadlock clause with just the simplest write-up saying that in the event of any dispute, both sides shall mutually agree on the approach, which sounds very nice until you realize that the whole point of a deadlock clause is to deal with the situation when parties can't can't find their own path and own way forward.
Yeah.
But that was their instructions, and we had to accede. Sometimes our clients, again, for better or for worse, think they know better than we do. And I cannot profess to know more than my clients. I can only give advice, from the way I see things. But they insisted upon it, and that was what was done. 1 year later, unfortunately, a dispute did actually arise. They couldn't agree about how to manage a particular project. And then, we turned to the shareholders agreement of the joint venture. How do we move forward from here? And the shareholders agreement said, as I said, that both parties shall mutually agree on the way forward. But the things they couldn't agree on the way forward. So what happened in the end? Well, what happened in the end was that both sides were threatening to sue each other for, adjacent breaches of the shareholders agreement. Demand letters were sent, and eventually both sides realized that no one was going to walk away the winner. And as many of these cases eventually pan out, a settlement agreement was signed pursuant to which the joint venture was voluntarily dissolved. But the entire process took over a year. Multiple counsels were appointed, not just in Singapore and in that jurisdiction, but disputes lawyers, involved in other jurisdictions that the joint venture had gone into for various reasons. Because, there were assets there, money there, and things like that. The whole thing could have been avoided and dealt with efficiently if parties had, as Mark said, right, put in place proper documentation, proper procedures, proper processes to deal with a situation in which they disagreed. But unfortunately, they did not, and that's what happened. So, coming into this call, I did a check how much legal fees were spent in the lead up to resolution.
Wow.
It was something just on my client's end. And let me just state for the avoidance of doubt that most of this didn't go to me. All right. I'm a corporate lawyer. Right? I'm not a disputes lawyer. Most of this didn't go to me. They spent 6 figures US just getting to that settlement. Whereas had they agreed from the start, right? My fee already included working out the shareholders agreement. They could have saved themselves that entire sum of money and that extended period of time and moved on with their business, gotten on with the project, either individually or with someone else. But yeah, they didn't, and that's what happened. So that's my example for you.
Wow. Thank you, Jeremiah. That's a real cautionary tale. And an example of when you try and even but you don't get it right, it still can be a problem. Mark, do you have any similar or perhaps maybe more positive stories that worked out better that you could share with us, please?
I think, first of all, I just wanted to say I agree entirely with Melanie and Jeremiah. In terms of how we actually, I don't really have that many positive stories to share, but I do have some clients coming to us with, again, disputes already on the hand, and I imagine how this all could be avoided at the initial stage of documentation. So I think really one big red flag, right, would be that I get that businesses would want to push out their products quicker, they want to push out their pitches to investors quicker, and all of them under time constraints that not necessarily that lawyers can fully understand. But I would caution and probably let all my clients know and potential clients know that they really need to set aside that time period for discussion, for documentation to take place in terms of what are the expectations, what are the agreed dispute resolution mechanisms, and all these need to be hashed out before they proceed on to the business proper. That would save so much time, so much cost down the road. That would remove all the feelings of personal attacks. It's not really a personal attack. People are just trying to make decisions according to how the document has stated and how it has been agreed. So you can actually move on to business faster instead of dwelling on disputes the whole time.
Yeah, very true. And Ray, we've worked with a few clients in this space with disputes in recent months. Any learnings you think that will be useful to share here?
So, obviously, we are in the business of helping clients start their business as well, right? So, a lot of conversations that we have with clients is now you're friends, now you're best friends, your husband and wife, your father and son, whatever relationship it is, right? You have to put in the worst case scenario. What if you get a divorce? what if you're no longer friends, right? On a personal level, you no longer have that relationship. Can you still deal with this person on a commercial basis? If you can't, then it's a recipe for disaster, right? Your disputes will all arise because of this. So very often when we have two friends coming in, oh, happily, we have this great business plan, we're gonna make millions out of it. Very often we just tell them, hey, who is the main guy here? There has to be a main guy, right? It can't be a strict 50-50. Then what if you have a deadlock? Who has the veto vote, right? So I think very much that's the advice that we can give to our clients. And yeah, through the recent experience with that few disputes that we managed to help mediate, I think again a lot of times if you catch it much earlier, as early as possible, and take action on it, less actions are required. The dispute has not deepened to a level that they don't talk to each other, or to a stage where the relationship cannot be recovered. Then that would be, acting early will be highly ideal.
Very practical advice and experience. Thank you, Ray. And it's obviously we have a powerhouse here of experience in corporate law and dispute resolution and mediation. And between the panel, it'll be great to get everyone's perspectives. But picture that sunny day when all the founders or shareholders are all happily celebrating their new venture and getting started. And they all agree, well, no, we don't need to worry about this. We don't need a shareholder agreement. We don't need a founders agreement. We don't need dispute resolution or governance like we talked about. What would each of you say to those founders at that point in time to help them understand maybe the value of giving some thought to preparing for how you would handle disputes when they may inevitably arrive further down the road? Maybe Mark, you want to start kick us off?
Sure. I mean, I would be a bit of a Debbie Downer. I would actually caution them, okay, it's great that you have all of this in place, but what you additionally need to have in place, or what you additionally need to think about, would be how are you going to settle, not so savory scenarios, right? I'll paint out some scenarios for them. Okay, if this happens, what are you guys going to do? If that happens, do you have a process in place to settle that? So I'll play a bit of the devil's advocate. At the same time, of course, I won't discourage them, but certain things that they may have agreed upon without the benefit of legal counsel, I would try to manage that as well. Yeah.
Yeah, great point, Mark. And Jeremiah, how about you? How would you try and help them on their way?
Oh, I'd do the exact opposite. At that point, if they're all out dancing in the sun, I would drink their champagne and celebrate with them. Because at that point in time, it's too late, right? They've already entered into agreement with each other. They've already subscribed for their shares. I'm not going to rain on their parade and tell them that, hey guys, you know what? This marriage is gonna fail. Nah, you don't do that, right? Like, I mean, you go for weddings between some people who should not get married to each other. You don't object to the wedding and go, guys, you don't do this. It's going to end in divorce. I'm not going to do that. I'm going to go there, drink the champagne, eat the buffet, wish them the best, and hope nothing happens. But then, of course, if I don't know if I can say this, given that this is supposed to be a recording, but if shit hits the fan, I would be prepared to give Melanie and Mark's number. So I'm not this lawyer. I'm able to assist thereafter. When it hits the fan, I will to Melanie and Mark saying, hey, guys, this thing happened. Can you help? And that's probably the best advice I can give. If you've waited till after you've subscribed for shares in the joint venture, you've put your money in, at that juncture, it's a little bit too late, right? Because the money's already gone in. Like, how are you going to incentivize somebody who's already done a deal with you to then back away from whatever benefits or obligations or rights he may already have under the Constitution, which is itself a shareholders agreement? It is the overarching primary binding shareholders agreement between the company, the shareholders, the directors. You're not going to be able to do that. It's not something you're going to be able to do easily unless, of course, it's a quid pro quo type situation, and the other side also sees some value in superseding that arrangement for him. So yeah, I wouldn't as Mark said, right, be Debbie Downer. I would jam the fun, friendly, council, having fun with the rest of the directors and the shareholders.
Well, perhaps, Jeremiah, perhaps the most chilling advice of all of them would be to welcome them to proceed on and enjoy the legal fees that will ensue later on. That might get them to pause for thought. Melanie, how about you? What would your take be?
Yeah, actually, it happens more frequently than you can imagine. So I can understand why Jeremiah takes that view. In many sort of family, high net worth families, they just run into JV, sign it, and then throw it on your table and say, hey, let's process this, execute this. Um, so while it has been done, you can't do a prenup because they're already married. I will certainly try a postnuptial. What does this mean? This means bringing the parties back together after the hangover, maybe the day after, bringing them all to your office, setting sort of, I'm very into fundamentals and checklists in case you haven't noticed, because I think this is objective, this is independent, it is not whichever party wants it or likes it. These are the tools that us legal professionals, whether you're corporate or dispute lawyers, will place before your client, force them to apply their minds to it collectively. And then taking a little bit of Mark's wisdom and say, what would happen if this scenario? How would you react? How would you react? How do you then together want the company to react? So I would really force them to sit down, and then think through some of the issues, some of the risk factors, some of the SOPs. It needn't be overly documented, but conceptually, some basic guidelines on how a company would want to react in a certain way if certain things happen. And going back to the earlier point about negotiating certain clauses. So, what we have done for small, medium enterprises, because you don't want to overburden them with documentation, paper, and all that. They don't want to do that. They want to do business. They want to make money. I get it. Okay. So what we do is have some non-negotiable clauses, be it dispute clauses, be it jurisdiction clauses, law clauses, whatever it might be for that. So with this already preset terms, it would be sort of easier to move forward without having to negotiate every single terms vis-a-vis the internal company, because when you are negotiating externally. But what happens more often than not is there's a lot of internal talk happening. Why? Because the fundamentals internally hasn't been decided. Okay. And when you get that out of the way, I think at least whether the deal goes through with that third party or not, internally it doesn't cause undue strain and pressures and disagreements. So that would be what I do in this scenario.
That makes a lot of sense. So I'm hearing the clear voice of experience here from the professionals in this space that um, best of all is to consider this question even before you begin. So that is really the right place to grasp this nettle and to define everything as much as you can. But of course, if you don't, then after the fact and as early as possible is still better than not. And to get involved, and even Melanie, to your point, even the very simplistic basics of jurisdiction or process or mediation will help you a lot in later situation if you need to get into difficult, complicated situations.
So sorry, I'm just going to jump in here and
Please, Jeremiah.
just throw my 2 cents in, unsolicited 2 cents, if I may add. Um, I completely understand where Melanie and Mark are coming from. But here's the thing, right? If you wait until someone is married to then sit them down and have that discussion about whether or not to do a post-nup, you're going to put a sour taste in everybody's mouth. And it may not end as badly as, we very jaded lawyers think, such unions typically do. But you don't want to, sorry, please edit this properly. But the point that I want to make is essentially this, right? Doing it post facto, after the fact, is going to leave a very sour taste in everybody's mouth. And in a union, a joint venture, or a marriage, you don't want to start that relationship off that way. And here's the thing, right? You can't force somebody to sign something that they don't want to sign, but you're already tied down together. And there is a shareholders agreement in play, and that's your constitution. If it's a standard constitution, then equity is king. Of course, there are minority rights, but equity is generally king, right? Because equity gets to vote in the board of directors gets day-to-day management of the company, so on and so forth. But yeah, it's just important to keep in mind that if you've already done this, right, do you really want to raise this now? What is the upside and the downside to it? Things work out, you get all those procedures that we talked about done. So not too late, you manage to salvage the situation a little bit. But what's the downside? The downside is that you piss off your partner. You then become a little bit suspicious of him or her, in the event that, he or she does not want to sign whatever you're asking for. It's not a great way to start a relationship or a union. And it then basically sets in motion that failure really, really early on. Which is why I said, if people are already celebrating their marriage together at that point, it might be a little too late.
Yeah, I just want to jump in here. So I think that's definitely a very legitimate scenario that Jeremiah was mentioning. So just to clarify, when I'm a Debbie Downer, I usually whisper in the ear of my client and basically just paint some scenarios for them to consider. So it's not necessarily they would, go ahead to, okay, I need to get this done right now, right after celebrations. But it's more of, seeing as how to, each business relationship is different. They need to also calibrate and know how to work certain things in, certain requests in along the way. And I guess that is a relationship actually that the counsel as well as the clients will build up together with the counterparty. It's more than just 3 months of work. Probably is a year-long relationship. So they might come back to us for more advice on how to work certain provision into the existing agreement that they have. So I think it still can work, just that we need to be a bit more calibrated about it. Yeah.
You have to manage it very carefully.
Yeah.
I cannot imagine if I met my wife now and said, you know what, I really love you, but I think we should get a post-nup done. Bro, I would sleep outside. I would sleep outside. And here's the thing, right? And even if he gave me what I was asking for, me being the very neurotic lawyer that I am, I would then be wondering, well, why did she agree to this? And if she did not, I would then be thinking, well, why did she not give me that? It's only fair, right? And imagine whatever you're feeling, the other side's feeling as well. So, that's why I say I really like what Melanie led with, the second question posed to her. And that is that you really need to take a step back first. These things should be done sooner rather than later, which also ties in with Mark's main point as to why why do all these disputes occur, and one of the points of failure is the lack of an agreement in relation to how they are properly managed. So yeah, I just realized I've got IP cameras around me, because I'm doing this recording from my house. Babe, I'm not getting a post now. Out loud for the record.
So I think the passion coming through here is built on, I'm sure, many years of pain and suffering in cases that you've worked on.
Pain and suffering, not in my marriage. Pain and suffering in cases that we
yes, corporate, business-wise, definitely not personal, I'm sure. And Jeremiah, you certainly undermined, of course, the practical and the realistic aspect of making sure that you do this before rather than after. So So maybe Jeremiah, if you want to come in again, or anyone else, but what is the best approach then before consummating or getting started with the new venture or the new business that you're planning to start? What is the best way of handling this, best practice wise?
Well, exactly what Melanie and Mark have already said. Ensure that you get in bed with someone that you can live and sleep with, and that applies equally to marriage. And ensure that you've got an agreement in relation to how that union is going to be run together jointly early on. I don't really have much else to add to that. Those are truisms that have stood time immemorial.
Mm. I, to play sort of devil's advocate, I imagine that all of those people lining up in our office starting new ventures feel that they have exactly that and that they're completely confident. But Melanie, maybe I throw it to you. What is that best practice document that Jeremiah is speaking about? Mark has been speaking about. You've been sharing. What's the best way of codifying this, preparing and protecting the venture to go forward?
No, I think all the fundamentals that I've mentioned about how they wish to approach the business. So they go first to the corporate lawyer, and then they go and speak about what sort of business structure they want. Obviously, these are the basics that need to be agreed on. The shareholding, if one wants to talk about the checklist of things they have to agree on, how dividends are intended to be taken out. I mean, it might not be in there, but I know everyone talks about it at the start because we are talking about a revenue earning entity. And moving forward, if there are share options, call options, all sorts of mechanisms which allow people to add on or exit, depending. Valuations are also put in. I think my learned corporate colleagues are best suited to explain the details of that. But for myself, like I said, and I keep repeating, I think you must start on the basis that you have the same vision, the same concept of how you want the business to run, how you want the business to grow. What are you looking at? 5 year, 10 years. Once you have that shared vision, and we keep analogizing to marriage for a reason, because this is a marriage in business. And once you have that sort of consolidated, I think, yes, details certainly matter, but where you're going to live, how you're going to live, are primary considerations before you even decide to go down the road of checking off the further details and the nitty gritty.
Well put. Yeah, then you can't overestimate that shared vision. And Mark, anything you want to come in on this?
Yeah, I don't have much to add. I think Melanie and Jeremiah have covered it quite well. So in terms of how this will all come into a document is, usually a founders agreement or a shareholders agreement. And there are certain, I'm sure some founders are already very much aware of what usually goes into these agreements, or some founders are actually aware of investor requirements, but they would really clearly set out how certain defaults or certain disagreements should be settled, whether it be a buyout, whether it be a termination, whether it be, move to a type of dispute resolution such as mediation or negotiation. So it's very important to have this document so that everyone has something to refer to. Everyone can at least agree on what they're going to do in terms of a dispute. If you're going to have a dispute and then you're going to dispute further on how you're going to solve that dispute, it's just too many, disputes, too many disagreements for it to be settled quickly, settled expeditiously. So, yeah.
Thank you, Mark. Yeah, that's. I hope this is somewhat of a public service announcement for all of those shareholders, business owners, founders, future founders out there to give consideration to. But perhaps we also have to deal with the practical reality that most of the people out there are going to ignore what we said and plow on regardless. Maybe, as Jeremiah said, celebrate the party first. Um, let's imagine we're in a scenario where the disputes come along and we haven't necessarily got all of those points defined. As specialists, as legal experts, do you think there's a role for specialists like yourselves to help people navigate these situations, maybe to mediate, to find a common ground, and how would you approach that? Perhaps Melanie, if you want to, do you want to start?
Yes, maybe I start with an actual case that I did several years ago. It was two brothers running originally a father's company. So that's very common in Singapore. We are all in second, third, fourth generation businesses. The situation arose, as I said from the beginning, different personalities, and they felt they were contributing different amounts than they thought they were. So, in terms of remuneration, obviously the CEO, chairman of the board, was remunerated at a higher value. And then you're talking about succession. One of them had a son who wanted to carry on the business, the other didn't. So we mediated for about a year with very senior judges at SMC, and I never thought it would settle. I really never thought it would settle. We all thought it would go on for an 8 week trial. Hooray to the dispute lawyers! But because this was a family dispute, I was trying my hardest to make sure that the relationship could be salvaged, which is almost impossible, honestly. I think Jeremiah is nodding. It's almost impossible. How do you have a corporate commercial fight, break up the brotherhood in the company, and yet retain that? So what we came out was a very innovative plan. We allowed for, let's say, a 3 year, 5 year, I can't remember the details, 3 year, 5 year step off, okay, for the elder brother, 3 to 5 years step up to the son of the other brother, which was brilliant because the younger brother wanted his son to also come into the family business. But yet it was not to the disadvantage of the elder brother because he was just giving up one part of the share, not all. Then it was to be decided how the younger brother and the son wanted to sort of uh, proportionately share the additional shares. And with that step off, they were allowed to actually combine their expertise, take on all the clients that the older brother had closer relationships with, and then agree on a final payout, depending obviously on the net profits at the end of the 5 year or 3 year, and give a huge sort of golden handshake to the older brother who would step off. So we managed that, I thought, beautifully because everyone got most of what they wanted, you see, without destroying the business. And that really took threats of, I'm going to leave, I'm going to sue you, let's see what the judge says, throw down papers, that kind of dispute, because it is very emotional when you have a family, especially an elder brother who feels that he has given the younger brother everything. So with that kind of very sort of traditional mentality, I think we all went back happy and had our champagne thereafter. In order to also stabilize the ship, what we did was to put in sort of a trusted, very senior employee to help stabilize, because the elder brother was of course worried whether the brother and the son would able to take over the business completely. So with that kind of, like, senior minister, minister mentor concept, we were able to also ensure that external parties, optics wise, they felt that the ship was stable enough for the contracts to continue with the company. So that allowed longevity of the relationship, longevity of the business as well.
It's a great story, Melanie. Thank you. And I'm glad to hear that the champagne can be popped even after these situations too.
Yeah.
Um, Mark, would you like to share some similar or other contrasting examples if you have them?
I don't really have an example that comes to mind, but I think it's more of how it just goes to show how lawyers don't just take on a legal counsel role, but I think you take on a role of just being from the outside, providing a different perspective to your clients. Because sometimes when there are brewing disputes, right? Parties tend to be very dug into their positions. I have to remind my clients, that while I'm looking out for your interests and I do everything I can to protect your interests, you know, to consider that the counterparty position may not be something that is so unreasonable, and to just provide a different perspective for them to consider, to bring parties first to the negotiating table, to then get each other to see the side of the other person, to be able to get them to even consider speaking to each other, to consider working out a deal that can hopefully be a bit of a win-win at the end. It's not that easy. And oftentimes it does not work out, but that's at least what we try to do in that situation.
It's a great point, Mark. And Jeremiah, any examples you have on this as well?
I've got a couple. For some reason, I've been involved in a number of quite public board fights. Most recently, just last month. And I can talk about this because, well, actually, I don't know if I've been named. I know my firm had been named, but I was the lead partner on that. SGX listed company, board fight, 2 different camps with different views about what to do going forward. I will say this. I think your question was, how external consultants, right, like counsels, can come in and help in a situation where parties have already started warring. And I think Melanie really nailed it, right? We test perceptions, we reality test what people feel, about their positions. We explore alternatives, and then we break the deadlock. And external consultants would do very well, because otherwise, without a third party's point of view, each side may just cling on to their entrenched positions and views. I will say this though. So going back to, the point that we made at the start, that very often directors have larger than life personalities or egos. Often, not always, often. Bringing counsels in can be a bit of a double-edged sword, especially if the counsel doesn't act for the entire board or is advising as an independent, but on one side. And I've got some personal experience here. Again, because I've done a number of board fights, very public ones as well. So Melanie is the head of enterprise disputes at Wong P, right, Mel? I'm sorry, I don't remember your full title. It's very long, and it's a very position. So, and Mark himself, associate director at Asia Practice. These are learned friends who really uphold and extol the great profession of law. But not every counsel is like that. And my experience has been, sometimes counsels come in with their own sort of agenda, right? Either because they feel so passionately about their client's position that as a fiduciary they cannot help but encourage, them to not settle and to persist in their position. But at other times, maybe because, and I'm not saying that many counsels are like that, but there definitely exists a minority of us who, sometimes put our professional involvement first. It can result in a situation where, instead of actually helping to diffuse the situation, as happened in Melanie's example, they actually make it worse. Either because they're actively encouraging the dispute and edging parties towards, full-blown litigation or arbitration, or if not, because, they, just their appointment sends the wrong image, right? The wrong signal to the other side. One way forward in this situation is to have the board as a whole, the company as a whole, right? Not representing, any one side, appoint counsel to advise everybody independently. So this counsel is not conflicted. He really is just representing the position of the law and his views. And I think someone in that independent position is going to definitely help, de-escalate any dispute. More likely than not, anyway.
Mm. Great points and a really interesting idea that you don't see it as a confrontation with two sides. You put one party in the middle, and before you need to go to a mediator, why not have a legal expert see the position in the middle? Um, and Ray, we've faced some cases recently where we've had, we've spoken a lot about founders and shareholders, but also director disputes, where we've also faced issues in that space. Any examples or good stories, hopefully, that you can share about how we've leveraged support from legal counsel and professionals to help get good outcomes in those kind of cases?
I think the most recent case that we've seen is a failure in director duties. I wouldn't be so specific to name exactly what area, but it's very obvious the director have not carried out the required responsibilities that he's entrusted to have. The shareholder wasn't too pleased. Sitting outside of Singapore, they weren't sure, what it entails to remove the director if they choose to eventually do so, and what kind of recourse do they have. So we did refer the client to legal counsel, one firm to look after, to give advice, and and it's an ongoing situation at the current moment. So it'll be good to hear from the experts on this panel. Some cases, live cases, or past case studies that you have around this topic.
Melanie, anything you can share on this topic?
Sure. I think this was probably a public listed. It was in the papers, but I won't name the company. We helped with sort of the transition. So it founder company maybe 20 over years ago, if we start counting from today. In 10 years, went into listing. 12 year issues with the board, because I think things started to kind of unravel, perhaps because some of the underlying governance fundamentals were not seamless. Then there was unhappiness, as usual, with the shareholders with one part of the board and wanted them removed. This is, again, I think Jeremiah is very familiar with these fights. But we did, again, what I thought would never happen. We managed to use the different influence of the different board members to reach out to the key shareholders to try to agree on a middle ground. CEO, acting CEO, means agree to remove one individual rather than, kill off the whole board, replace one of them with someone who was, I would say, neutral, not the most popular, not the most hated either, someone neutral, but with a steady hand, seemed to be independent as one can be in certain situations. And that averted certainly the entire breakup of the board. I mean, this company has recently, last year, also been in papers with certain changes of the board members. But what I want to say is, and Mark is correct on this, we are counselors, historically. That's why we are called legal counsel. Ultimately, uh, I stand in the shoes of the company. I advise the company as a whole, not pursuing or pushing one particular sort of strong voice or lead actor, as I call them. And I advocate different scenarios, different individuals, and ultimately they make the decision on whether they want to see themselves through choppy waters, or they are potentially risking uh, the ship not sailing anymore. So this is what I think is very important when you have legal counsel that is looking out for the company as a whole and pushing it forward in the best interest of the company, not who is the biggest shareholder, not who has the loudest voice in the company. And I'm sure my colleagues here know it takes metal to do that, because it's not always the thing that people want to hear. But that is our role. And like I always tell some of my juniors, if they don't want our counsel, then it's okay, we will step away. But we are not going to mince our words or act uh, inappropriately. As Jeremiah said, some I've seen some myself, that's not pursuing the genuine interests of the company as a whole. So that is not what we would do. We would say, as hard as it is to hear, we would assert our advice regardless of whether it's popular or not. But if those are facts, those are our true advice, then we will go on that. So I hope that answers Ray's questions on how one would approach certain scenarios without breaking up the entire board.
Great perspective. And Jeremiah, you might have some perspectives to also share.
No, I think Melanie summarized exactly how I feel about things. I don't mince my words, which is why I'm just a small lawyer in a small firm. Should learn to shut up sometime.
You gotta edit that out, Ivan. All these, comments for himself.
It's true. It's true. The fact is, unfortunately, I have not learned to keep a lid on it. But yeah, I think good counsel is really important, and not just legal counsel, right? There are a lot of other stakeholders involved in the business. As Melody pointed out, you've got the shareholders, you've got the directors, you've got the company secretary, right? These are people who have a front row seat to any brewing dispute and who would be in a position to move first and try and help diffuse anything before it becomes an issue that is bigger than it really should be.
Yeah, they're great points that all of us as professionals really should try to be part of the solution and give the right advice, even if it's unpopular.
I mean, any mediator, any judge, anyone who does dispute resolution, alternative dispute resolution, will tell you that you need to find the key to every different human being. Every solution has to be packaged in a different way. And to me, that is what I call beyond legal advice. This is not a black letter, not what the contract says. Everyone knows what the contract says. How do we get a solution beyond the contract that will survive? This business can survive beyond that. That is the question that we all have to answer.
Yeah, and it's a noble goal, and it makes much more difference. Mark, any final words on this topic?
I think I fully agree with what Melanie said. There's need to not just say the right answer, but say it at the right time, say it to the right person, say it in a way that they'll be receptive to your message. And that really is an art, and something I think my colleagues over here, seasoned legal counsel, will be able to help with. And to also actually just remind your client that really you don't have you don't have that kind of vested interest that they have in it, and that's precisely why you can give the best and most objective advice that is suited for the situation. So I think really it takes time to be able to understand your client fully so they can deliver the solution to them in the correct packaging.
Yeah, there's huge value in an impartial third party, and especially one with those superpowers that Melanie mentioned of persuasion and unlocking people's objectives and goals. I just want to give Jeremiah and Melanie also a chance for any final words as well. Anything you wanted to add before we wrap?
Well, if I had to give just one last piece of advice, it ties in with Melanie's and Mark's point, right? And that is, be honest, right? Be honest at the start, try and figure out early on what you really want out of that union. The more BS you spew at the start, the more gets flung back at you when it hits the fan. So be honest and, work out your arrangements, your tie downs early on, because that's going to form the bedrock of your cooperation and partnership, for the many years to come. Hopefully. If not, make sure you got Melanie Mark's number on speed dial. I can't help you there. I wish you guys all the best. But yeah.
Well, a huge thank you to our panelists, Melanie, Mark, Jeremiah, Ray, for your time. I really appreciate you giving up the time. Sorry we went a little bit over, but I really appreciate it. We will be in touch again around the recording and the edits and clearing them by you. And if I can just remind you again that when we finish here, if you could just leave the Riverside app, the window open and you'll see a percentage uploading figure hopefully on your end, and you'll see when it's 100% and you can close the window. But huge thank you again. We look forward to partnering together going forward, and really appreciate your contributions today. Thank you, everybody.
Thank you.
Thank you.
Bye.